So what we wanted to do today was introduce our panel. The panel is entitled Today's Interpretation of Computer Laws Developed for a Bygone Age, blah, blah, blah. And it is a very long and entitled, a long name that we attempted to switch, but what the purpose of the panel is to go and introduce some of the tension between law and technology, particularly with respect to computer crime statutes that were drafted, 30 years ago. What we want to do is examine some of the changes in law, some of the changes in technology and business, and as well as international reach in terms of how computers have changed, technology has changed, and whether or not laws have changed along with technology. We have a very esteemed panel today. We have Dennis Riordan here, a noted criminal defense attorney at Riordan and Horgan here in San Francisco. We have Peter Newman, who presently is a, Peter, what's your title?
Neumann, Senior Principal Scientist.
Senior Principal Scientist at SRI down in Menlo Park. And Peter, if I kept reading his biography, it would take a very long time. He's the author of several noted publications and member of many esteemed groups. We have Ray Agayan, who is a trial attorney and a former federal prosecutor. He used to prosecute with the Cyber and Intellectual Property Crime Section of the U.S. Attorney's Office at the Central District of California. Ray presently is in private practice. And we have Vicki Chou, who's presently an assistant U.S. attorney in the Cyber and Intellectual Property Crime Section of the National Security Division of the U.S. Attorney's Office for the Central District of California. So with that, I was going to pass it to Andy. Andy was going to introduce some of the issues at a high level.
Thank you very much, Mukund, and thank you for coming. To make a long story short, there are quite a number of computer statutes, criminal that have civil components, that are in use in the courts nowadays. And the problem that is being observed is that many of these statutes were written decades ago, and the technology has changed, and the use of the technology, our ordinary course of business conduct, has dramatically changed, and the statutes are being applied in areas that they were never anticipated being used in. So to discuss that, this panel has come together. And I'd like to give you a little story. It's not quite on point, but I think it makes the case of why we're here. And this goes back about 20 years when I still had some hair and it had color. I was an assistant U.S. attorney in Boston, and there was something known as the Michelangelo virus. Some of you here may remember it, and most of you probably don't. But the decision was to try and track down the perpetrator of the virus. And we found that it was being distributed unintentionally from a computer company outside of Worcester, Massachusetts. The FBI, at that time, not knowing what computer crime was nice enough to give me one of their senior agents. And the two of us drove out towards Worcester. And the virus was embedded in the software for the mouse that was being distributed. So we spoke with the people who developed the mouse software. And we talked to the people who maintain the mouse software on a gold disk that they kept, hidden away in a vault. And we spoke with the people who marketed the mouse. And we spoke with the people who updated the mouse. And we spoke with the people who fielded complaints about the mouse. And this went on for about 5 hours. At the end of the day, my FBI agent had been dutifully taking notes. Walks out to the car with me, and before we get in to drive back to Boston, says, "Andy, I have a question for you." "What?" "What's a mouse?" I was tempted to say a little furry gray animal with a tail, but I remembered he was the one who was packing and I wasn't, so I didn't do that. But the point that I'm getting at is here was a law enforcement endeavor that wasn't in tune with the technology. And here we have legal regimes that, in the opinions of many, are not in tune with modern commerce and modern definitions of technology. So this is what we're going to address today. And on the panel, we have Dennis Reardon, who has recently argued a case in front of the Ninth Circuit, Nosal 2. And he, some years ago, won Nosal 1. It concerned the Computer Fraud and Abuse Act and its definitions of authorized access and exceeding authorized access in the context of policies and restrictions within an employment situation. And I'm going to ask him to start it off to discuss what he considers to be some of the more confusing and at-issue topics within the Computer Fraud and Abuse Act. And then I'm going to ask Mr. Peter Neumann, Dr. Peter Neumann, who is a renowned expert in the field of computer science and cryptography and software development. And I will say this, I know Dr. Neumann for a while. He is one of the leaders in an organization called the Association for Computing Machinery. That organization is the computer society for computer professionals, much like the ABA is for lawyers. And I'm honored to sit on a national policy committee with him. So I'm honored that he also decided to come here today. With that, Mr. Reardon, would you take the floor?
Thank you. Opinions from intermediate appellate courts very rarely are grist for the mill around the water cooler on Starbucks line, and with the exception of law blogs, they rarely attract attention in the general media. But that was not the case last month when the Ninth Circuit handed down its second opinion in the United States versus Nosal case, a prosecution that's been going on for about 11 years now. The internet just lit up with articles about Nosal 2, and in fact, it had made it to the Hollywood Reporter, all opining on what was the possible meaning of this opinion. Now, I've had some appellate cases that have drawn a fair amount of public attention, but it's usually because of the sensational, if not grisly, aspects of the charged offense, or the fact that the defendant was someone who had already been a public celebrity. But Nosal 2 is the first time where all the hoopla is about the intricacies of interpreting statutory language. In this case, the language of the Computer Fraud and Abuse Act, 18 U.S.C. 1030 and following provisions. Just a little factual background. Nosal was charged with CFAA and trade secret violations based on allegations that he and some of his associates who had left a major search firm, KFI, to start up their own search business, that after they did so, some of the associates got back into, in one way or another, got back into the computer at KFI and downloaded some source lists. Source lists are just lists of possible executive candidates with their addresses and contact information, sometimes more, but in this case, pretty much bare bones information like that on candidates that you use when you're trying to fulfill a search. In Nosal 1, which was decided on an interlocutory appeal before trial, the issue was the meaning of the term accessing a computer in excess of authorized access. In Nosal 2, which followed the defendant's trial, Nosal 1 was, we lost 2-1 before the panel and 1-9-2 in an en banc decision. Post-trial, the Nosal 2 decision came down last month, and the key issue there was what without authorization meant. The reason why these issues are so thorny is that these two statutory terms were written into the CFAA in 1986. Try and put yourself back in 1986. Here's a Congress acting to protect against possible invasions of improper hacking into computers. How many people in 1986 had the expertise, to say nothing of the physical hardware, to enter into any computer other than the ones with which are relatively few, had those rickety old laptops on their own desks that they could get into. So the universe of possible perpetrators that these statutes were directed at back in 1986 was really, really quite small. Now we're in 2016, where literally hundreds of millions of people can gain access to the computers of major financial institutions with the great encouragement of the institutions while walking down the street with their handheld devices. So the court is confronted with the task of trying to figure out how to apply these statutes to a phenomena that, quite frankly, the framers of the statute probably couldn't even imagine would ever exist. And it's a difficult task, and in both cases have produced some highly polemical results. In Nosal, and one reason for that is that the CFAA has a number of provisions, and in a number of them are directed at acts of fraud or damage. Well, all well and good. I mean, if somebody's trying to defraud, if somebody's trying to damage something, that certainly seems like nefarious activity that ought to be punished. And there has been a tendency, or at least one way of viewing this, is why don't we interpret exceeding access and without authorization very broadly to reach a lot of activity, because it's going to be narrowed by fraud and damage. We can have a broad interpretation of those statutes, but we're not going to sweep into our net anybody who doesn't deserve to be punished, because they have to be guilty in addition of fraud or causing damage to a computer. The problem is that the essence of a computer crime is not fraud and damage. The essence of the computer crime under the CFAA is found in provisions which don't involve fraud, damage, or any other criminal activity or intent. They simply define it as a crime to enter a computer in excess of authorization or without authorization, and during the course of which you simply obtain information from a protected computer. By the way, a protected computer is now every computer that exists. Any computer connected to the internet is a protected computer for the purpose of the statute. So what the court then had to do necessarily is come up with definitions, a meaning for exceeds access or without authorization that would fairly apply, that it could live with, when applied to people who weren't doing anything like acting to defraud or seeking to inflict damage. Those are felony offenses as opposed to the basic offense, which is a misdemeanor. And in Nosal 1, what it was all about was that a employee of this search firm had used her password to reach information that the company was perfectly comfortable with her reaching. It was within the scope of her job, except, of course, there was a company regulation or policy that the information could only be used for business, the business of KFY. And what she had done was downloaded it and then passed it on to friends of hers who had left the firm, who were then in the process of working outside the firm and starting their own new firm. So the government's argument was, look, that at the moment when, yes, she can get this information, KFI said she could, but only for a limited purpose. So at the moment that she uses it for a purpose not defined by the company, then she's acting in excess of authorization, and that is a CFAA violation. And the Ninth Circuit, the en banc opinion, firmly rejected that. And it said, here's the reason why. If we accept that definition, that means that what is a crime under the statute is not defined by the statute. I mean, if you have a policy in one company that employees are absolutely not to get on their computers during the Sweet 16, then, and you do, that's a federal crime. And another company, if they don't have that policy, it's not a federal crime. We have to have a definition that doesn't turn on company policies which reach an enormous amount of activity, which may be properly the basis for firing, may be properly even for the basis for prosecution for some other crime. But we can't turn all of these into federal crimes. And therefore, if you're in a computer in an area that the company allowed you to get in, and you're abusing that permission by using it for an improper purpose, you may be in trouble for a lot of reasons, but you're not guilty of a CFAA violation. And one thing they emphasized in that was the rule of lenity. And they emphasized the fact that, look, the government's going to say, we're not going to go chase people, who are on their computer during the Sweet 16. But the point that they made is that if you make this into a federal crime, then you give an employer the power, whenever it's to their advantage, to turn to an employee and say, we can report you for a federal crime. You have a sexual harassment case against us, you better drop it, because we've got this lever over you because you acted without authorization in terms of your computer. So that's Nosal 1. Nosal 2 comes along, and it involves actually the same employee at KFI. Example number 1, she had access to the computer. She got this information. She gave it improperly to somebody else. In number 2, two factual scenarios. 1, she gets onto the computer, uses her password, but then somebody else sits down and runs the keyboard. Example number 2, she simply gives the password consensually to somebody else who doesn't have a password, and a former employee who once had a password, and he or she gets into that and downloads some of these source lists that we're talking about. This comes up under the without authorization prong of the court, of the statute. And Judge McEwen, who had been in the majority and the 9-2 majority on the en banc opinion, now writes the 2-1 opinion affirming the conviction. And where does all the interest come from? Because essentially, what this person, the difference between Nosal 1, where she uses her computer for an improper purpose, her password, Nosal 2, where she grants permission for someone else to use her password, is password sharing. So if you go on the internet, you will find articles like, can Hillary Clinton be prosecuted for getting into the Donald Trump website because if she used somebody else's password to do so? And there's a huge spectrum of activity where people share passwords, where obviously they do it for non-nefarious purposes. And one of the important things, to get back to the theme of this, which is attempting to apply these statutes 40 years after the world they existed, in which they were created, existed, was there was an amicus brief really coming down in the middle in Nosal 2 saying, look, the government's position is that password sharing is entry into a computer by sharing a password when the owner of the computer has not specifically given you permission to share your password. If you adopt that, that is so out of touch with modern realities. For instance, right now in the cloud, there are entities and apps in which a person gives to the app all of their passwords for all of their financial accounts for security purposes. And they check into those accounts regularly to make sure there's no irregularities going on. Well, the person who has the passwords hasn't gone to each of the banks or financial institutions and gotten permission to share the password. But they have given authorization to this company app working for them to go ahead and access all of their accounts. If password sharing is the essence of the crime, then that's criminal activity. And they took a very strong position that the government had to, that the court had to reject the government's position. The government really put forward another argument that, interestingly enough, didn't seem to do well at oral argument. It said, look, all of that stuff, parents demanding their kids' passwords so they can check on it, all of that stuff, we're not talking about that. We're talking about the employment context. That's what really matters. That's where nasty stuff or bad stuff can go on in the employment context. And Judge Thomas said there's nothing in the statute about the employment context. We have to paint on a broader canvas than that. Nonetheless, the majority opinion seems to emphasize very clearly that the employment context made a difference to them. The other part of it is that in the majority opinion says, well, you know, in those other instances, people shared passwords, but they hadn't lost their password. In this employment context, the people here who shared the password and got into the computer once had passwords, but they left the company and lost them. So this is an instance in which people had their passwords revoked. So that distinguishes it from all of the other innocent activity that you can imagine. Well, again, there's nothing in the statute that has that says the definition of without authorization turns on having previously lost the password, and you can frankly think of lots and lots of situations that you might want to criminalize where somebody hadn't had a password and lost it. And so the distinctions that the majority draws here are ones, and quite frankly, there's passages in it where the majority seems to say, look, you know, we know it when we see it, we don't like what happened in this case, other things are different, and nobody's, you know, prosecuted anybody in those contexts yet, and we'll get to them when we get to them. But Nosal 2 leaves a lot of questions unanswered that will still have to be answered. And just two other considerations that I'd throw in. One big part of Nosal 1 was the rule of lenity. That is to say, you can have different interpretations of, in that case, exceed access. But if there's two reasonable ones, you've got to go with the non-criminal one. You cannot use criminal statutes to put people away when, for all they knew, what they were doing was consistent with the statute. And you look at the situation of the employee, I'll call her JH. In the first instance, the government comes to her and says, you're going to have to plead guilty because you got into a computer and then used information for an improper purpose, and that's a violation of the CFAA. Boom, a couple of years later, after she's pled guilty, Nosal 1 comes along and says, no, that wasn't a crime at all. That wasn't a violation of the CFAA. You acted with authorization rather than excessive authorization. Okay, the government thought one thing, she was told one thing, the law turns out to be the other. Nosal 2 comes along and says, oh, okay, that when you sat down and went into that computer and took that information, that was not in excess of authorization. However, you should have known that the statute made it a crime to allow somebody else to sit down and use the keyboard, or the statute made it a crime to share your password with somebody else. That's the kind of constitutional notice of what's criminal that must be provided under the rule of lenity. And one problem, and I'll stop with this whole process of applying statutes from 40 years ago to a phenomenon now which couldn't have been imagined, is it frankly is a little preposterous to suggest that that language of 40 years ago put people today on clear notice of what is and what is not a crime under the CFAA.
Great. I'm going to amplify on what Dennis, for those of you who came in late, I'm Peter Neumann. I've been, I guess I'm in my 64th year now as a computer professional. And I want to take you back in time. There was a time when California decided it needed a Computer Crime Act. The first act said, in essence, that it was illegal to read, write, alter, or delete information in a computer. Come on, think a little bit. This means you can't use a computer, because that's all you do when you use a computer for good purposes. I once confronted somebody in the legislature and said, you know, this is ridiculous because this is overly broad. And he said, yes, but we'd never use it against somebody who wasn't doing something wrong. Okay, so instead of going back 40 years or whatever it was when that came up, I'm now going to go back 28 years. And again, amplifying what Dennis has said, the Internet worm, November 1988, was an experiment that was conducted by a graduate student who had worked at Bell Telephone Laboratories for a summer And during that summer, he had discovered all sorts of problems with computer systems, serious flaws, serious wide open things. So he took all those together and created the internet worm, which was supposed to be completely benign. It would be undetectable. He made a colossal mistake, and it blew up on him. But the question of exceeding authority when there is no authority is a slippery slope that I want to present to you. There were several cases, for example, let's take the password file that he used. He gathered thousands of common passwords by basically reading from computers that he had access to the encrypted password file, which was unprotected. It was wide open. Anybody could read it, anywhere in the world, practically. And he reverse engineered some of those. His father had written a paper years before about how to extract passwords and what you should do to fuzz them up so that they couldn't be hacked that way. So he used that, and he had a whole bunch of passwords. Now, here is a case where the password file was not protected. It was wide open to the world, and he used it. Another case was the so-called .rhosts file. This is a file which exists on all Unix-based systems. It says which of my files or file directories or whatever can I export to the world. And it turns out that I had a client from the U.S. Army, and he came by and he said, hey, let's take a look at White Sands. And we discovered that White Sands was exporting to the world all sorts of sensitive files. Okay, no authority was required. These are wide open files to the world. Now, was Robert exceeding authority when he accessed files that were available to the world? Slippery slope. Probably not, because no authority was required. The clinker in this pile comes up with, the finger demon, where you can ping somebody's email address or their login address on a remote system, and the system would tell you whether they're up, are they working at the moment. There was a bug in that. Now, the bug allowed you to execute arbitrary code on the system that you were pinging. There's a fundamental flaw in the system. Is that exceeding authority? No authority was required. But the clinker in this whole thing is the send mail debug option, which the creator, Eric Ullman, insisted was a feature and not a bug. This was something where he could debug things that were going wrong with your system, with the mailer, if something had broken. And he could get through the send mail program and actually get access to your system. Okay, it was not a bug, it was a feature, and it was in the system, and it required no authority whatsoever. The question is, was Robert Morris exceeding authority? So I think what I'm trying to point out that there are all kinds of corner cases and slippery slopes in the case or in the situation in general or in the laws as they have evolved. I was reading this document here, the Prosecuting Computer Crimes by the OLE, and it says the term without authorization is not defined by the CFAA. The term exceeds authority means to access a computer with authorization and to use such access to obtain or alter other information. Now, Dennis was talking about passwords. If I give you my password, it may be perfectly legitimate if the policy of the company that I'm dealing with does not say you should never share your password with anyone. On the other hand, given most of the operating systems that we deal with, which are already broken, Almost every one of them has flaws that allow anybody to climb in and do anything they want to, even though you may not realize that. That's a fundamental problem with all of the vendors' software that we have today. The problem then becomes, suppose I have legitimate access to something, and I grant Dennis access to read and write or alter or delete or whatever one of my files that I happen to own. What's the difference between my giving him a password and my giving him access to those files? Another slippery slope. So I can go on for a very long time on this subject. I'm not going to, but I want to suggest that in the context of the crypto wars that went on in the 90s, where law enforcement wanted access to all sorts of things, and the FBI was in trouble because the one guy I knew in the bureau who I'd been working with for years to build a insider misuse detection system was co-opted by Louis Freeh, who came up to him and said, "Hey, you're an agent. You can't be dealing with computer security. This is not in your purview, and you got to go back to being an agent in the field." This was the one guy in the bureau who understood computer security. So they shot themselves in the foot in the mid-90s when that happened. And I think the problem with law enforcement today is that they're in a terrible bind. They do not have the competence, they do not have the training, they do not have the experience to be able to break into all of these systems which, as I've said, are already broken. So they want exceptional access so they can read plain texts, because they can't deal with the encryption, for all of these systems in such a way that nobody else can do it. And what you've seen recently is the Chinese and the Russians and many others eating our lunch, basically. I have a letter in my pocket from the OPM, which says that my account was one of the 2 million or whatever it was of clearance applications that was compromised. The Chinese have access now to everybody who has gotten a clearance or even applied for it and denied a clearance. Their mistresses, their ex-wives, their drug habits, and all of this stuff is in that application for the top secret clearance. So when you recognize that everything is already broken, the idea of throwing back doors in something that is already broken can only make it worse. And we even have 3 people named Michael, one former director of NSA, another a former director of National Intelligence, and one former director of Homeland Security, all saying you can't dumb down security for law enforcement, because if you do, everybody else will have access to it. So that's the beginning of my story, and I'm not going to go any further than that. I hope we're going to get through this and have a lot of questions from the panel on each other and panels from questions from the audience.